The most important SCOTUS case of our lifetime. So we chose the Grutter versus Bollinger case as the most important SCOTUS case of our lifetime, which happened in 2003. A bit of background on the case. It was argued on April 1st, 2003, decided on June 23rd, 2003 at the University of Michigan Law School graduate admissions. The petitioners were Barbara Grutter, Kirk O. Colbo, who argued in favor, and Theodore B. Olson, who was the supporting petitioner. The respondents were Lee Bollinger and Maureen E. Mahoney, who argued in favor. A bit of background on the purpose of the case. So, in 1997, Barbara Grutter, who was a white resident of Michigan, applied to the University of Michigan Law School. She applied with a 3.8 undergraduate GPA and a 161 LSAT and was denied admission. The school admitted that it used race as a factor in making admissions decisions to promote diversity. The petitioner argued she did not get in because the school predominantly used race as a deciding factor of admissions. The issue under question was whether the University of Michigan Law School's use of racial preferences in student admissions violated the Equal Protection Clause of the 14th Amendment or Title VI of the Civil Rights Act of 1964. The petitioner's argument was that the University of Michigan was using race as a factor in making admissions decisions. They admitted that it served as a compelling interest in achieving diversity among its student body. Also, it seemed to intentionally discriminate against whites, which would then go against the 14th Amendment, which states that no person shall be denied within its jurisdiction to protect the citizen's equal rights. The Equal Protection Clause states that no person shall be compressed of its privileges as a citizen or denied life, liberty, or property without legal jurisdiction. Title VI of the Civil Rights Act of 1964 states that no person in the United States shall, on the ground of race, color, or national origin, be excluded from participation in, be denied the benefits of, or be subjected to discrimination under any program or activity receiving federal financial assistance.
This case is very important for us as teens who have just finished the college application process because the way that we are admitted and judged is extremely beneficial to know. This decision impacts all of us students because now we understand the reasoning behind putting our race and having a more unbiased decisioning process. It's also reassuring to know that the courts rule in favor of promoting more diverse campuses. With having a diverse community, we then become more aware and learn about other cultures to enhance us as human beings. This photo was taken as the protesters in 2003, and it was just highlighting the moral basis for taking affirmative steps and actions and decisions in courts to make sure that, especially the Black American society, does not get discriminated no more. The outcome was a 5-4 decision with 3 major factors. One, that it was not determined by race entirely. The court law decided that the law school considers a serious evaluation of each individual during their review and that no rejection or acceptance is entirely determined by their race. In addition, the diversity on campus was looked further upon as the school wants a diversity among its student body, so race will sometimes affect the close decision process to amplify the diversity. In addition, it did not violate the Equal Protection Clause by identifying a race when applying. And overall, the law school conducts highly individualized review of each applicant. No acceptance or rejection is based automatically on a variable such as race, and that this process ensures that all factors that may contribute to diversity are meaningfully considered alongside race. And this is our sources page.